This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we tell a man bites dog story why fraudsters in New York must pay the insurer back plus interest for their fraud. And GEICO and many GEICO companies got big judgment against no-fault insurance fraudster. On August 4, 2022, Plaintiffs Government Employees Insurance Company and other GEICO companies commenced a suit against a bunch of healthcare providers for common law fraud, unjust enrichment, aiding and abetting fraud, negligent misrepresentation, civil RICO violations, and a declaratory judgment alleging that the defendants schemed to submit fraudulent no-fault insurance claims. Receiving no response to their suits, the plaintiffs moved for default judgment on the common law fraud claim against a Mr. St. Louis and one Brooklyn, collectively called the defaulting defendants. In Government Employees Insurance versus Wilkins, Williams, P.C., Eric St. Louis et al., the United States District Court for the Eastern District of New York on September 6, 2024, entered the default judgment requested by GEICO. New York enacted the Comprehensive Motor Vehicle Insurance Reparation Acts, the No-Fault Act, in New York Insurance Law Sections 5101 to 5109 for prompt compensation for losses incurred by accident victims without regard to fault or negligence, to reduce the burden on the courts and to provide substantial premium savings to New York motorists. Plaintiffs underwrote automobile insurance in New York. Insured drivers can assign their rights to no-fault benefits, which include up to $50,000 for necessary expenses to healthcare providers in exchange for healthcare services. Healthcare providers submit claims directly to insurance companies via an NF-3 or an HCFA-1500 form and then receive payment for provided medical services. These forms contain warnings that filing claims with false information or concealing information is a crime. The no-fault laws state that a health care provider is ineligible to receive no-fault benefits if fraudulently licensed, if paying or receiving unlawful kickbacks for patient referrals, or if permitting unlicensed laypersons to control or dictate treatments, or if allowing unlicensed laypersons to share fees for professional services. The alleged scheme alleged by the plaintiffs is that Mr. St. Louis holds himself out as a healthcare industry practice manager and operator of various healthcare offices, but are in actuality organized to supply convenient one-stop shops for no-fault insurance fraud. Plaintiffs allege that the defaulting defendants ran a scheme that systematically submitted fraudulent no-fault claims to plaintiffs for unnecessary medical services by illegally using the medical license, signature, and other relevant information from a Dr. Wilkins B. Williams. Dr. Williams, and by legally controlling Williams Medical. The defaulting defendants, in coordination with the John Doe defendants, created the claim paperwork to bill for fraudulent services. The defaulting defendants created a stamp with the name of Williams Medical, Dr. Williams' national provider number and medical license number, and then placed that stamp on assignment of benefits and medical record forms with Dr. Williams' forged signature to misrepresent that Dr. Williams performed the services. The defaulting defendants worked with the lawyer defendants to provide billing and collection services for their fraudulent medical services. Finding that Mr. St. Louis was properly served, the court concluded it had personal jurisdiction against him and similarly had personal jurisdiction as to one Brooklyn. To state a claim for fraud under the New York law, a plaintiff must allege 1. A material misrepresentation or omission of fact, 2. which the defendant knew to be false, 3. which the defendant made with the intent to defraud, 4. upon which the plaintiff reasonably relied, and 5. which caused injury to the plaintiff and also requires allegations of fraud be pleaded with specificity, which requires that the plaintiff 1. detail the statements or omissions that the plaintiff contends are fraudulent, 2. identify the speaker, 3. state where and when the statements or omissions were made, and 4. explain why the statements or omissions are fraudulent. Plaintiff sufficiently alleged the defaulting defendants knew the submitted claims were false. The allegations sufficiently demonstrated that the defaulting defendants knew the claims were false and fraudulent. Further, plaintiffs sufficiently alleged that the defaulting defendants' conduct on which plaintiffs reasonably relied caused plaintiffs to pay $542,374.05 for fraudulent bills submitted through Williams Medical. Unchallenged facts established the defendant's liability, and the court determined the amount of damages due. In addition, New York law provides for the award of prejudgment interest on damages computed from the earliest ascertainable date the cause of action existed. If the insurance fraud context, prejudgment interest accrues from the date the insurance company makes payment. The court found that granting prejudgment interest beginning the first day of the first quarter following when plaintiff made payments is permissible, and the defaulting defendants presently owe plaintiff $91,408.42 in prejudgment interest on a $542,374.05 total paid to Williams Medical. In a scheme where there are repeated fraudulent acts, the multiple defendants, plaintiffs are entitled to recover once for every fraudulent act, and each defendant who participated in the fraudulent act is jointly and severally liable for the amount of damage caused, and the defaulting defendants are therefore jointly and severally liable for the damages. In conclusion, the court found that the plaintiffs demonstrated that the defaulting defendants are liable for common law fraud, and therefore the court entered judgment in favor of plaintiffs and against the defending and defaulting defendants for $542,374.05 in compensatory damages, $91,048.42 in prejudgment interest, plus $33,301.26, calculated as $133.74 per day between January 1, 2024 and the date of the judgment, September 6, 2024, the date the clerk of the court's entry of final judgment, for a total of $124,340.68 of interest. Should the date of judgment be beyond September 6, 2024, the clerk of the court is instructed to add additional interest of $133.74 per additional day from September 6, 2024 through the date of the judgment. Moreover, post-judgment interest shall accrue from the date of entry of the judgment as provided by 28 U.S.C. 1961. so that an additional $133.74 is owed for every day until the judgment is paid in full. In my opinion, the judgment may have an effect on the community of fraudsters taking advantage of insurers writing auto insurance in New York by taking profit out of the crime. Since this is a default judgment, GEICO will probably have a difficult time collecting the judgment, but it will chill the others trying to defraud insurers in New York. The finding might even make it possible to convince the U.S. attorney and the state and local prosecutors to prosecute the crime that was committed by the defaulting defendants, as well as all of the other defendants alleged to have defrauded GEICO. Since there was no prosecution, GEICO must be commended for its proactive effort to stop fraud. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and have access to the more than 4,850 blog postings. Please tell your friends and colleagues about this blog and the videos and let them subscribe to the blog and the videos. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, to subscribe to my Substack publication. Thank you for your attention.